Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we come to you with a mega episode rundown for the January cases. I hope you all listened to the individual case previews. You can find them on our podcast page. But if you didn't, or if you want a refresher, listen to today's mega episode to get up to speed. Here's today's game plan. We'll talk about the Supreme Court schedule, then tick off a housekeeping matter or two. Then we'll dive into the cases. Before going any further, here's your reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, or wherever you podcast. You can also follow us on LinkedIn, or you can email us at scotus.cases.pod@gmail.com. Feel free to reach out on any of these platforms if you have any questions or would like to just talk about the Supreme Court. All right, let's talk Supreme Court scheduling. In this episode, we'll talk through the January schedule. After January, the Supreme Court doesn't return again until the end of February, almost an entire month. On top of that, they only sit for 3 days during that entire month. I imagine they'll take that time to speak at symposiums and conferences and to even trickle out opinions. The justices will sit for 8 days in March and 7 days in April. The court hasn't yet set oral argument dates for May or June, but I imagine that we'll see them do so pretty soon. Right now, the Supreme Court has 48 unique cases pending. I say unique cases because that means I'm only counting the consolidated cases once. So, for example, on the upcoming case, Little v. Hecox, that case was consolidated with West Virginia v. BJP. I only count that as one unique case. Last year, the Supreme Court heard about 63 unique cases. So I'm thinking that the Supreme Court will start to slot in at least 10 or 15 more cases to hear and decide this term. We may even see them do so as early as this week or next week. Okay, let's quickly talk housekeeping. On my LinkedIn and YouTube pages, I've recorded 60-second summaries for each case. I'll replay those 60-second summaries here. But for some of the cases, I'll add a few more details. If you're looking for more details than what you hear here, please check out our episode-specific previews. Finally, sorry about a few of the AI voice glitches. There's been a couple, not many, but more than I want. The software voice, the AI text-to-speech software I use doesn't flag glitches. And so in the middle of a script, I once heard a voice start speaking in Polish for no reason. I don't know why the glitches happen. And once I hear them after publishing, I can't really edit the podcast file. I use AI voices because it's faster than me reading, but I wish those glitches didn't occur. Thanks for bearing with me. All right, let's tackle the upcoming cases, and we'll go in order of oral arguments. On Monday, January 12th, the Supreme Court will hear Chevron v. Plaquemines Parish. Thanks to a YouTube commenter for correcting my pronunciation. Plaquemines, not Plaquemines. Here's a summary of Chevron v. Plaquemines in 60 seconds. During World War II, oil companies like Chevron produced aviation fuel for the federal government. The oil companies made crude oil in Louisiana using 1940s methods like earthen storage pits instead of steel tanks, partly because the government needed steel for the war effort. Today, Louisiana parishes want to sue these companies for $744 million, claiming those production methods now violate environmental laws. The companies say, wait, we were helping win the war under federal contracts, so you have to sue us in federal court, not Louisiana courts where judges might favor the hometown parishes. The question, do Chevron's wartime efforts protect it from local courts 80 years later? There's a few through lines in this case I want to highlight. First, let's start with the oral advocates. This case will be argued by Benjamin Aguinaga. This will be his third oral argument this year. His first being Calais, his second being Landor. He's Louisiana's Solicitor General. I highlighted him in an earlier episode this year where I thought that he did an excellent job with an oral argument opening statement. He'll be going against Paul Clement, who will also argue his third case this year. The other two being Cox versus Sony, the $1 billion broadband battle, and Bost v. Illinois, the case about standing. It asked whether, before an election, a U.S. House representative can challenge the constitutionality of ballots received after Election Day. This case evokes similar federalism concerns as First Choice Women's Resource Centers v. Plaquemines, which the Supreme Court heard oral arguments last month. That's the case where an organization tried to sue in federal court instead of state court when they were trying to fight a subpoena that the New Jersey Attorney General issued to them. On Tuesday, January 13th, the court will hear Little v. Hecox consolidated with West Virginia v. BJP. Here's a 60-second summary of Little v. Hecox and West Virginia v. BJP. Transgender female students sued Idaho and West Virginia after state laws blocked them from participating in sports with the gender of their identity. These states permit students to participate on sports teams of the gender of the person's birth biology, not their gender identity. The states defend by pointing to male athletic advantages in strength and speed. The students argue blanket exclusions discriminate unfairly and that courts should consider individual circumstances instead. This case follows United States v. Skrmetti, where the Supreme Court upheld Tennessee's ban on gender transition care for minors. The Supreme Court must answer in this case, can states ban transgender women from female sports? United States v. Skrmetti will feature heavily in this case. That case was decided about 7 months ago. Skrmetti, the court upheld Tennessee's ban on puberty blockers for minors looking to change their gender identity. I'm oversimplifying just a little bit, but that was the gist. Writing for a 6-3 majority, Chief Justice Roberts recognized broad discretion for states to ban certain medical treatments. Does it seem likely that they'll say, yeah, Skrmetti, but this ban on women's sports goes too far? Probably not. The biggest question in my eyes will be whether the Supreme Court applies a rational basis or intermediate basis to evaluate the laws. Over this past summer, I did an entire episode on the levels of scrutiny. I'll link to that episode in the show notes in case you want to learn more. On Wednesday, January 14th, the Supreme Court will hear CSX Gillette v. New Jersey Transit Corporation consolidated with New Jersey Transit Corporation v. Colt. Here's a 60-second summary of CSX Gillette v. New Jersey Transit Corporation. A New Jersey Transit bus rear-ended a car in Philadelphia, injuring a passenger. The passenger sued in Pennsylvania court. Transit said, "You can't sue us here. We're the state of New Jersey. We have sovereign immunity." Here's the twist. New Jersey's own law explicitly says transit isn't the state, and the state won't pay transit's bills. The Supreme Court must decide, can transit authorities receive sovereign immunity when a state disclaims responsibility for the transit authority's debts? Case. Gillette will be the fourth sovereign immunity adjacent case the Supreme Court has heard this term. The others include Hensley versus Floor, Lander versus Louisiana Department of Corrections, and GEO Group v. Menocal. I'm curious to see the sovereign immunity landscape after this term, given the multiple opinions I'm really curious to see how they're able to fit the puzzle pieces together to continue to create a coherent landscape, even though they're taking on these different cases with slightly different nuances to them. Also, a fun fact, Gillette is the only case this month where the United States will not participate in oral arguments. On Tuesday, January 20th, the court will hear two cases. The first case is Wolford v. Lopez. Here's a 60-second summary of Wolford v. Lopez. Hawaii passed a law saying gun owners need explicit permission before bringing firearms into any private business, like restaurants, stores, or coffee shops. Most business owners never post signs about guns either way, so licensed gun carriers don't know if entering makes them criminals. Jason Wolford and other permit holders sued, arguing this effectively bans carrying guns in public since you can't read business owners' minds. Hawaii says property owners have always controlled who enters their land and what they bring. The Supreme Court must answer, can states require gun owners to get advanced permission for something the Constitution protects? To understand the Second Amendment landscape, you must understand two cases and a recent Supreme Court certiorari denial. These two cases are Bruen and Rahimi. Bruen and Rahimi established three principles for gun laws to comply with the Second Amendment. First, Americans have the right to carry guns in public for self-defense. 2, gun regulations must find support in America's historical tradition of firearm regulation. Third, courts cannot balance public safety against constitutional rights. History alone determines what regulations survive. In 2022, Bruen struck down New York's restrictive concealed carry licensing laws using this historical test. Courts can no longer weigh competing interests when evaluating gun laws. Instead, courts must examine whether modern gun regulations match historical practices from America's founding era. In 2024, Rahimi applied this test to uphold federal laws disarming domestic abusers. The court found sufficient historical precedent in colonial-era laws targeting dangerous individuals. Now, Wolford tests whether states can restrict gun laws through principles of property law. We'll see how the justices interact with the historical traditions regarding property law and how they overlay over the laws on gun restrictions. Expect history and tradition to feature heavily in this case. On Tuesday, January 20th, the court will also hear M&K Employee Solutions v. Trustees of the IM Pension Fund. Here's a 60-second summary of M&K Employee Solutions v. Trustees of IAM. 4 companies withdrew from their employee pension plan at the end of 2017. When they left, they owed money to retirees. Think of it like getting a restaurant bill. You eat dinner on December 31st and ask for your check. The waiter calculates your total using that night's menu prices. But here's the crazy part. 3 weeks later, the restaurant says, actually, we're using the higher prices we adopted in January. Your bill is now 3 times higher. That's what happened here. The pension plan changed its math after the fact, tripling what companies owed. The companies said, you can't charge the prices after we ate. Now, the Supreme Court must decide, can pension plans charge higher prices using future prices, or must they stick with the original price? Let me know if you found the restaurant analogy helpful. I'll classify this case as probably the driest case of the January cases, but I'm interested to see how the court grapples with after the fact changes. This case also made me think about ex post facto laws. Ex post facto is a Latin phrase meaning after the fact. Ex post facto laws are laws that retroactively change the legal consequences of acts committed before the law went into effect. The U.S. Constitution generally forbids ex post facto laws for criminal laws, but not civil laws. Let me give you an example. Let's say Congress passes a law that makes it a felony for people to talk on their cell phones in the car. One day after the law goes into effect, you get arrested for talking on your cell phone. But not for talking on your cell phone that day, but for talking on your cell phone 3 years earlier. The Constitution prevents your conviction. It's not quite the same scenario as this case, M&K, but you can see the overlapping features. Justice Kavanaugh, Gorsuch, and others are particularly concerned about people and companies receiving fair notice of events. And textualists place a strong preference on conduct that occurs at the time of an event in question. So I can see the conservative justices taking issue with the calculation change here. And finally, on Wednesday, January 21st, the court will hear Trump v. Cook. Here's a 60-second summary of this case. Here's a 60-second summary of Trump v. Cook. President Trump fired Federal Reserve Governor Lisa Cook after finding out she allegedly lied on 2 mortgage applications in 2021. She claimed both a Michigan house and a Georgia condo would be her main residence at the same time, possibly getting better loan rates. President Trump gave her 30 minutes to resign, then fired her when she refused. Cook sued, saying presidents can't fire Fed governors without good reason and without proper notice. The Supreme Court must answer. Can presidents fire Fed governors for personal conduct that happened before they got the job? Can courts second guess presidential for-cause firing determinations? And do government officials deserve a hearing before getting fired? If you have a bingo card, you might as well slot in now words like unreviewable, preclusive, and deference, because we'll likely hear those words in spades. Expect the United States to advance similar arguments as they did in the Trump tariff cases, especially about the scope of and reviewability of the president's authority. Here's the kicker. We need to look at this case through the lens of Trump v. Slaughter. Remember that December case about whether the president can fire an FTC commissioner without cause? Because if the court rules in Slaughter that the president can fire the FTC commissioner without cause, then the for-cause restriction in this case no longer holds any meaning. It wouldn't make sense, on the one hand, to say the president can fire a person for whatever reason, but if they give a reason, we can question it. Trump v. Cook may only matter if the court rejects Trump's argument in Trump v. Slaughter. All right, that's it for today's mega episode. Thanks for listening to the High Court Report. Please follow, rate, subscribe, and share the podcast. You can find us on Apple, Spotify, YouTube, and wherever you podcast. Follow us on LinkedIn. Hit us up on email, scotus.cases.pod@gmail.com. Talk to you soon.